Today on Don't Talk TV, I'm going to take a look at the Canadian Bill of Rights of 1960. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. A recurring question that's come up in the comments box and in emails has been, why do you always refer to the Charter? Why don't you ever look at the Canadian Bill of Rights? Why aren't lawyers using the Canadian Bill of Rights instead of the Charter of Rights and Freedoms? It seems to me that a lot of people think that since the Canadian Bill of Rights doesn't have a Section 1 that allows for reasonable limits that are demonstrably justified in a free and democratic society, that therefore the rights outlined in the Bill of Rights are unlimited, and you can do whatever you want as long as you can fall under one of those. I've often used the example for religious liberty that if it was unlimited, people could convert to ancient Aztec religion, kidnap people off the streets, cut their hearts out and sacrifice it to the sun god, and then say, I can't be charged with kidnapping or murder because my religious liberty is protected by the Charter or by the Bill of Rights. Frankly, I think that's just wrong. No right is unlimited, and we'll take a look at the Bill of Rights. We'll see what some of the limitations are there, and we'll also look at a Supreme Court of Canada case discussing the use that's to be made of the Bill of Rights in a Canada where the Charter of Rights and Freedoms has been in place for many years. So first of all, let's look at the Canadian Bill of Rights itself. I'm just going to skip over the preamble, but Section 1 here is probably the one that's most important to viewers. Lays out the Declaration of Rights and Freedoms. So it says that it is hereby recognized and declared that in Canada there have existed and shall continue to exist without discrimination by reason of race, national origin, color, religion, or sex, the following human rights and fundamental freedoms, namely A, the right to the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. Now that one almost exactly reflects Section 7, although you've no doubt noticed the enjoyment of property included that is excluded in Section 7 of the Charter. The next one is the right to individual to equality before the law and the protection of the law, freedom of religion, freedom of speech, freedom of assembly and association, and freedom of the press. Now, here's a couple important things. The Bill of Rights basically has its own Section 33 notwithstanding clause. It says right here, every law of Canada shall, unless it is expressly declared by an act of Parliament that it shall operate notwithstanding the Canadian Bill of Rights, be so construed and applied not to abrogate, abridge, or infringe, etc. As you can see, that's basically their Section 33. They can invoke a notwithstanding. That's baked right into the Bill of Rights. Furthermore, if we look down to the bottom here, I think this is also important, the jurisdiction of the Bill of Rights. The provisions of Part 1, and Part 1 being where that Section 1 was laying out the rights, the provisions of Part 1 shall be construed as extending only to matters coming within the legislative authority of the Parliament of Canada. In other words, the Bill of Rights only applies to federal legislation. It doesn't apply to anything else. So that is the number one reason why the Bill of Rights is not used by lawyers very often, because for something done by the province, actions of the government that aren't necessarily a law, those aren't covered by the Bill of Rights, but they are covered by the Charter of Rights and Freedoms. Charter of Rights and Freedoms, being the highest law of the land, since it's built right into our Constitution, is always and everywhere applicable to any government action. Now, I want to take a quick look at a 2003 Supreme Court of Canada decision. The Attorney General of Canada and Joseph Patrick Authurson, deceased by his litigation minister, etc., referred to as Authurson versus Canada. It's 2003, 2 SCR 40. As always, I'll post the citation in the show description below. So if we go down to the analysis section starting at paragraph 31, there's some useful comments by the Supreme Court here. Paragraph 31 says, it's useful to consider the limited jurisprudential history of the Bill of Rights. The Bill of Rights is a federal statute applicable only to federal law. So that goes with that last section I quoted when we were looking at the Act. Then states that where federal legislation conflicts with the protections of the Bill of Rights, unless the conflicting legislation expressly declares that it operates notwithstanding the Bill of Rights as required by Section 2, the Bill of Rights applies and the legislation is inoperative. Then carrying on to paragraph 33 says that Section 1 of the Bill of Rights declares and recognizes various rights, including the due process right to the enjoyment of property that is at issue here. The Bill of Rights protects only rights that existed in 1960 prior to passage of the Bill of Rights. And they give a couple of examples. For example, death penalty statute was found not to be in conflict with the Bill of Rights because the right to life didn't exist prior to 1960, and the right to uniform sentencing across Canada did not exist prior to 1960, so that's another thing that didn't apply. Then at paragraph 34 it says, with the constitutional amendment and the adoption of the Charter in 1982, many of the protections of the Bill of Rights gained constitutional status. The Bill of Rights, however, provides two protections not expressly available in the Charter. Section 1A protects the enjoyment of property, the deprivation of which must occur through the due process of law. Section 2E guarantees a fair hearing in accordance with the principles of fundamental justice for the determination of rights and obligations. The Canadian Bill of Rights would certainly be very useful in any case, again, dealing only with federal statute where one's economic or property rights are being infringed. And that's what was done in the Authorson case, is that there were property interests at stake. That's not protected by the Charter of Rights and Freedoms, so you can then use the Bill of Rights. But again, there's a hierarchy of laws. The Constitution is the highest law of the land. The Charter is part of the Constitution. Therefore, that is generally what will be used. On a practical level, unless you're dealing with something specific like property rights, there's no advantage to using the Bill of Rights over the Charter of Rights and Freedoms. At common law, there's always going to be understood to be some level of restriction to rights. They can't all be unlimited, as per the example I gave earlier. That's written explicitly into Section 1 of the Charter, but frankly, I think the test laid out in Section 1 of the Charter, in which I've done in more detail in a previous episode, may well give you more protection than the common law analysis of limitation of rights. So I hope that explains why I tend not to reference the Bill of Rights, or why lawyers in general tend not to use the Bill of Rights and instead use the Charter of Rights and Freedoms, which is part of the highest law of the land. This video is not legal advice. If you need legal advice, you can contact a lawyer, can call another lawyer, or myself, with the caveat that as of the filming of this episode, on October the 20th, I'm currently not taking new clients because I'm too overwhelmed. But if you're watching the show at another time, my number and email address are listed below. And if you have show topics that you'd like to hear about, please leave a comment in the comment section below or send an email to the email address listed. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, and subscribing, and following us on social media.